Open our alumni lunchtime webinar presented by Professor Tim McCormack. Tim is a relatively new Dean of the University of Tasmania Law School. My name is Janine Arnold and I'm the Associate Director of Alumni and Events in the Advancement Office at the University. I'm a proud alumnus of the University, having completed both my undergraduate and postgraduate degree here. The Advancement Office is in part responsible for alumni relations, events and protocol management, and is committed to providing our alumni globally with meaningful ways to connect to their university. This includes lifelong learning opportunities, such as our public lectures and forum series, and of course, webinars such as the one we are delivering to you today. These webinars are also an opportunity to introduce to you employees of our university, or alumni who have key roles in the community. People like Tim, who are leaders in their field of expertise, and highly valued within our institution. This webinar will form a living record for the university, which you will be able to access from the university's website. As we progress through the lecture, there will be an opportunity for you to post questions to the live stream channel, and we will then ask those questions of Tim at the end of the webinar. Professor Tim McCormack has returned to Tasmania after spending much time working interstate and internationally, becoming one of the world's foremost experts in international humanitarian law. Tim grew up in Burnie, Tasmania, experiencing what he has been noted as saying, an idyllic childhood, full of family, friends and freedom. Tim graduated from the University of Tasmania with honours in 1982 before going on to specialise in international law, first by completing his PhD at Monash and then as the inaugural Australian recipient of the Goldmeier Postdoctoral Fellowship at the Hebrew University of Jerusalem. Tim is a specialist advisor on international humanitarian law to the Prosecutor of the International Criminal Court, a Director of World Vision Australia, the inaugural DFAT Visiting Legal Fellow, appointed jointly with Professor Anthea Roberts for 2017, and the New Zealand Law Foundation Distinguished Visiting Fellow for 2018, hosted by the University of Canterbury Law School. Tim has held a number of significant international positions, including a Senior Fulbright Fellowship, as a James Barr Ames Visiting Professor at the Harvard Law School, a law of war expert advisor to Lieutenant Colonel Michael Dan Morey for the defence of David Hicks before the US Military Commission Guantanamo Bay, and an amicus curiae on international law issues to the judges of the International Criminal Tribunal for the former Yugoslavia in the trial of Slobodan Milosevic in The Hague. The University of Tasmania is extremely fortunate to have someone of Professor Tim McCormack's expertise as the Dean of our law school, and we are very grateful to him for delivering this webinar to you, members of our alumnus community today. I'll now hand over to Tim.
Thanks very much, Janine, and I too am a proud alumnus of the University of Tasmania. And for me it's a great privilege to come back home to Tassie and to take up this new role. I'm delighted that the University has invited me to deliver this webinar, and to those of you alumni, staff and friends of the University around Tasmania, elsewhere in Australia and around the world that are watching and listening in, thanks very much for joining me in relation to a topic that's close to my heart, the International Criminal Court. Between a rock and a hard place, are we asking too much of the institution? I should say right from the start that I am delivering this presentation in my personal academic capacity, not as Special Advisor on War Crimes to the Prosecutor of the International Criminal Court. Nothing that I say can be attributed to her office, and while she's, I'm sure, happy for me to talk about the court, I want it to be known that these views are my own. I'd like perhaps to do a few things today, to explain a little bit about the International Criminal Court, to explain how the jurisdiction of the court works, and then just try to unpack some of the inherent tensions and perhaps irreconcilable differences of expectation about the court that respond to the question that I'm posing in the title that's been assigned. So first of all, some basic information about this new court, well, relatively new court. I guess it's not so new. This year, July 2018, we marked the 20th anniversary of the opening for signature of the Rome Statute that establishes the International Criminal Court. And earlier this year, in March 2018, we marked the 15th anniversary of the swearing in of the inaugural 18 judges, the prosecutor and deputy prosecutor, and the registrar of the court in a ceremony presided over by Queen Beatrix of the Netherlands in The Hague. So this court's been up and running now for 15 years. And these twin anniversary, the 15th anniversary of the establishment of the court, the 20th anniversary of opening for signature of the statute to establish the court, provides a really happy coincidence of anniversary, of timing, for us to ask some questions about expectations in relation to the court, about achievements perhaps to date and some of the challenges the court faces. This court is the world's first permanent international criminal court, and by that I mean to distinguish it from all the international criminal courts and tribunals that have preceded it, which by their nature have been ad hoc. And I'll explain a little bit more about the progression, historical progression and evolution to arrive at the establishment of the International Criminal Court. But the ICC, as we call it, not the International Cricket Council, of course, the other ICC, is constituted by 123 states parties at the moment, not quite 2/3 of the international community, but pretty close to that, with 18 judges, a prosecutor and deputy prosecutor and registrar, all elected from amongst the Assembly of States Parties, the body that's constituted by each of the states that have signed up to the Rome Statute and that are the decision-making body in relation to the court. Australia had a very significant role to play in the negotiation of the Rome Statute, and I had the privilege to join the Australian government delegation in Rome in 1998 to negotiate the terms of the statute. So I have this vested interest not only because of my current role as Special Advisor on War Crimes, but also because of my historic role in helping to negotiate the treaty that established the court. I have this vested interest in how the court's doing and what we can say about expectations in relation to it. Let me try to briefly explain some of the historical background to the establishment of the court, because there's a sense in which, on one hand, the court is the natural progression of this evolutionary process, but on the other, it represents quite a marked departure from what went before, and in some ways represents perhaps a new challenge or a new threat to notions of individual state sovereignty. So let me start with, first of all, some selected moments in the historical development of international criminal law and the establishment of the International Criminal Court. Perhaps the most appropriate point to start is the immediate aftermath of World War I. When the victorious Allies got together, established a commission on responsibility for the war, and they considered who, in their view, were those most responsible for the defeated Central Powers, from Germany, from the Ottoman Empire, from Bulgaria, from Hungary, responsible for the initiation of aggressive war and responsible for the violation of the laws of war, the perpetration of war crimes. That Commission of Responsibility drafted some pro forma provisions to include in each of the peace treaties imposed on the defeated Central Powers, Treaty of Versailles, the Treaty of Sèvres, imposed on the Ottoman Empire, for example. And these provisions envisaged the establishment of Allied high tribunals that would hold individual German defendants, individual Turkish defendants, criminally accountable. In the end, political decision was taken not to proceed with those tribunals and instead to allow Germany and the Ottoman Empire to undertake their own trials at the national level. Those trials in Leipzig in Germany and predominantly in Constantinople, now Istanbul, in Turkey, although in some other locations in Turkey's case, those trials collectively were seen as farcical by many in the Allied countries of Europe, especially those countries that had been occupied by Germany during World War I. And the reason why they were seen as farcical is because there were very few of them, very few trials relatively, very lenient sentences handed down to those who were convicted. And there was a sense in Allied countries that that we'd really let Germany and the Ottoman Empire off the hook. In my view, we can't really understand the resolve of the Allies in World War II, determined, if they won the war, of course, determined that when this was all over, they would this time around hold German and Japanese defendants to account. And that resolve was a major influence on the establishment of the Nuremberg and Tokyo war crimes trials in the aftermath of World War II. And those two trials, of course, the first international criminal tribunals. They've been subjected to sustained criticism about victor's justice, about the winning side imposing a system of justice on the losing side. We need to jump forward 45 years from Nuremberg and Tokyo to 1993. The Tokyo Tribunal concluded in 1948. 45 years later, the UN Security Council established the International Criminal Tribunal for the former Yugoslavia, and then the following year in 1994, the International Criminal Tribunal for Rwanda. Both of those two tribunals were in a sense a development on the Nuremberg and Tokyo model, not established by the winners of the war imposing justice on the losers, but established by the Executive Committee of the United Nations, the Security Council, for all sides to the conflicts in both country situations. So we are already seeing an evolutionary advance over the Nuremberg and Tokyo model. But again, we can make a criticism about those two tribunals. If it's good enough to have a tribunal for the former Yugoslavia and for Rwanda, why not also for neighbouring Burundi or the Central African Republic or Uganda in Africa's case, or a tribunal for East Timor or a tribunal for Guatemala or El Salvador? We could go right around the world and say this ad hoc approach to the creation of tribunals is not a comprehensive, global, impartial, systematic system of justice. Since the International Criminal Tribunal for the former Yugoslavia and Rwanda were created in the early 1990s, there's been a proliferation of ad hoc tribunals: the Special Court for Sierra Leone, the extraordinary extraordinary chambers in the courts of Cambodia, the Special Tribunal for Lebanon, a new EU-initiated tribunal for Kosovo. And all of these are modifications of the model that the Yugoslavian and Rwandan tribunals represent. And into the mix in 1998 we have the creation of the International Criminal Court, this time a permanent court, not limited to a single conflict ad hoc, but at least potentially with the jurisdiction to deal with alleged Rome Statute offences, genocide, crimes against humanity or war crimes, wherever they occur in the world. So that's the sense in which I'd characterise the International Criminal Court as a natural progression over this evolutionary process as we've developed more mature institutions in relation to the enforcement of international criminal law. But it is also true that the ICC is not just a natural progression, it's a departure from what's gone on. As I already mentioned, this court has not been created for a single conflict, but has the potential to deal with conflicts wherever they occur. It's been created by multilateral treaty, not by the decision of the victorious powers or not by the Executive Committee of the United Nations, the Security Council. And there is a sense in which this court represents an unprecedented threat to the sovereignty of states, because this court has the capacity under the Rome Statute. I'll explain how this works a little bit more very soon. But this court has the authority and the jurisdictional capacity to be able to try individuals who are nationals of non-states parties, countries that have chosen not to become or not to subject themselves to the jurisdiction of the court, where the conduct of those individuals occurs on the physical territory of a state which has signed up to the court. That, I think, is the most significant advance, or if that's a loaded term, the most significant aspect about the Rome Statute that distinguishes the International Criminal Court from all that's gone before it. Personally, I'd argue that it's an advance. Others, of course, would not do that. But there's a sense in which this new court, partly because of the advances that have been achieved, but also partly because of the way it's been established, creates arguably irreconcilable expectations. On one hand, the ICC is expected to be ideal. It's supposed to be committed to ending impunity. It's supposed to be normative. It's supposed to be principled. It's supposed to be transcendental, and it's supposed to be consistent. But it's also the case that the court is expected to be real. It's expected to engage with the assembly of states parties. It's expected to develop and carry the support of those countries. The court's supposed to be grounded. It's expected to be effective. And this tension between its ideal expectations and its real expectations are not always easily resolved. It's also true that the court, on one hand, creates a vertical regime in the sense of its exercise of legal coercion. It's conducting criminal trials. It's convicting individuals and sentencing them to extended periods of imprisonment. But it's also true that the court's acting on a horizontal plane. It's dealing with sovereign nation states who are used to only being bound by that international law to which they have consented, and consensus and consent are such big concepts in international law. So this tension between the vertical plane aspects of the court's work and the horizontal plane can also create irreconcilable expectations. This court's supposed to be independent, and yet it's thoroughly dependent on states and international organisations. This court's supposed to be effective, but it's also supposed to grow its legitimacy. So let me try and explain how the court's jurisdiction works, how it is that a case comes before the court, and then I can also unpack some of the polarised views about criticism of decision making, especially by the prosecutor. So in the Rome Statute, we have what we call 3 alternative triggering mechanisms, 3 mechanisms, any one of which must be triggered before there can be any proceedings before the International Criminal Court. The first of them we call a state party referral. So a country, a state, which is a party to the Rome Statute, refers a situation somewhere in the world where that state believes Rome Statute crimes have been perpetrated, alleges genocide or crimes against humanity or war crimes, or a combination of those 3. There are in fact 5 situations where states parties have referred the country situation that they're involved in to the prosecutor of the International Criminal Court. And they are the Democratic Republic of the Congo, Uganda, the Central African Republic, Mali, and most recently Palestine. In each of those situations, the relevant governments have come to the prosecutor and said, please help us with the challenges that we face in relation to justice issues arising out of the conflict situations where we find ourselves subjected to. The second triggering mechanism in the Rome Statute is the UN Security Council referral, where the Council refers a matter to the prosecutor of the International Criminal Court. And there have been 2 situations where that's happened. In relation to Sudan, and particularly the crisis in Darfur in the west of the country in 2005, and in Libya in 2011. Both times the Security Council, by resolution, determined that these situations should be referred to the prosecutor of the International Criminal Court to respond to the allegations of Rome Statute crimes perpetrated in each of the 2 situations. And the third triggering mechanism is what we call the prosecutor taking her own initiative to open a formal criminal investigation. The Latin expression is proprio motu powers. The prosecutor has her own authority to open a formal criminal investigation, but only where she convinces a pre-trial chamber of 3 judges, so she convinces at least a majority of at least 2 of the judges, that there are reasonable grounds for believing that Rome Statute crimes have been perpetrated in this particular situation. So we have this third alternative way in which the prosecutor has the authority to open a formal criminal investigation, but there is an extra check and balance on the authority of the prosecutor which does not apply to the first two triggering mechanisms, and that's the approval of the pretrial chamber at the request of the prosecutor. The pretrial chamber has given its approval on 3 separate occasions to the prosecutor to open a formal criminal investigation in relation to Kenya, in relation to the Côte d'Ivoire, the Ivory Coast, down on the west coast of Africa, and Georgia, in respect of Russian invasion of the northern provinces of Abkhazia and South Ossetia in 2007. At the moment, the prosecutor is waiting on a response from the pretrial chamber to a 4th request, initiated proprio motu, to be given approval to open a formal criminal investigation into the situation in Afghanistan. And we expect the pretrial chamber to hand down a decision in relation to that request any day now. In addition to these 3 triggering mechanisms, any one of which must be exercised for the prosecutor to be able to investigate the situation, there are 2 additional admissibility criteria, both of which the court must be satisfied of before the court is able to exercise its jurisdiction. The first of those is the consent requirement. The statute, the Rome Statute, specifies that the court must be satisfied that either the territorial state, the state on whose physical territory the alleged crime occurred, or the state of nationality, the state whose national allegedly perpetrated the offence, one or other of those 2 states must give their consent to be bound by the jurisdiction of the court. Now, in many situations of civil war, the territorial state and the state of nationality will be one and the same. There, in fact, will not be 2 separate states, and if that's the case, then there is only one state that can give its consent. In other circumstances, it could well be that there are 2 separate states, and we only need the consent of one of them, or the court only needs the consent of one of them to proceed. There are 2 ways in which a state can express its consent to be bound. If that state is already a state party to the Rome Statute, it is deemed to have consented to the court's jurisdiction, and no further action is required. If neither the territorial state nor the state of nationality is a state party to the Rome Statute, then that state has the option to accept the jurisdiction of the court ad hoc by declaration. And that's in fact happened once by the Ukraine, making a declaration accepting the court's jurisdiction in relation to the period of Russian invasion of the Crimea. Now, the interesting thing, or there are lots of interesting things, but one interesting thing about the consent requirement is that this requirement only applies to triggering mechanism 1 and 3. So it only applies to a referral by a state party or the prosecutor acting on her own initiative with the approval of the pretrial chamber. This consent requirement does not apply to triggering mechanism 2, referral by the UN Security Council. And the reason for that is that under the UN Charter, and particularly Chapter 7 of the Charter, the UN Security Council has unlimited authority. The members of the Council can decide that to restore or maintain international peace and security, they can authorise lethal military force against a member state of the United Nations, if that's what they believe is required. So this concession in the Rome Statute to UN Security Council authority is really a reflection of the constitutional authority that the Council has in the UN Charter. If the Council can authorise lethal military force without the consent of a state, it can certainly refer a situation to the prosecutor without the consent of the state. And so it is the case that neither Sudan nor Libya are states parties to the Rome Statute, and the prosecutor and the court nevertheless have the authority to proceed with cases because the Security Council overrode the requirement of consent in both situations. The second admissibility criterion is what we call complementarity. This is a term that you don't find in the Rome Statute itself. It's been coined to describe the relationship between the International Criminal Court and national courts. The Rome Statute, in a number of places, in the preamble, in Article 1 and also in Article 10, talks about the ICC as a complement to national courts, not to usurp them, not to override their authority, but to complement national courts. And what this really means is that the ICC, is a court of last resort. The ICC only has jurisdiction where national courts are unable or unwilling to deal with the case themselves. And the Rome Statute formula is unwilling or unable genuinely to conduct the trial themselves. And it's important to understand that this particular admissibility criterion applies to all three triggering mechanisms, including to those referred by the UN Security Council. So before the court proceeds to preliminary hearings and trial stage against an individual accused, the court has to be satisfied that both the territorial state and the state of nationality, both of which have a better claim on jurisdiction than the ICC, both of those states are either unwilling or unable genuinely to deal with the case themselves. And if either of them is willing and able to deal with the case themselves, then they have a better claim on jurisdiction. The statute unpacks those concepts a little bit in more detail. What does it mean to be genuinely unable? What does it mean to be unwilling? And if there are any questions about that, I'm really happy to deal with them in Q&A. But let me move on to explain the tensions in practice about competing criticisms of how the court operates or decisions that the prosecutor takes. Perhaps I could start with those situations which do not fall within the jurisdiction of the ICC, because it's quite an easy one to deal with. Perhaps it won't come as any surprise to you in the audience that there's a lot of criticism of why the ICC is not dealing with the crisis in Syria, now in its 8th year. I remember when the prosecutor announced in 2015 that she was opening a preliminary examination, a preliminary step to the opening of a formal criminal investigation into the situation in Palestine. The Israeli Defence Minister, Avigdor Lieberman, went right off his face and said, how dare she be interested in what's happening in Palestine or here in Israel, when just across the border in Syria, hundreds of thousands of people are being slaughtered. Well, he's right in one sense, but it's not the case that the prosecutor's not interested in the Syrian situation. It's the case that the ICC has no jurisdiction in Syria, because Syria is not a state party to the Rome Statute. And neither is Myanmar, neither is Iraq, neither is Zimbabwe. We could list a whole stack of situations that cry out for the intervention of the International Criminal Court, but the court is precluded from dealing with them because of those admissibility criteria and the triggering mechanisms. The Security Council has never referred Syria to the ICC. Twice the French have tried to do that, and both times the draft resolutions have been vetoed by Russia and China. So unless the Security Council is able and willing to refer a situation of a non-state party to the Rome Statute, the court has no jurisdiction. So the criticisms of the court's apparent indifference to these situations is really calling out for education. The Israeli Defence Minister and I could sit down and have a bit of a chat, and perhaps I could explain to him that it's not a question of indifference, it's a question of a lack of jurisdiction. But what about where the court does have jurisdiction and the decisions that are made in those circumstances? This is where we can have competing criticisms, and here I hope to be able to demonstrate that it doesn't matter what decision the prosecutor takes, it will always be subject to criticism. And that's not to suggest that the criticism is completely devoid of merit, because actually there might be some substantive merit to it. The point really is, I guess, that there is no perfect decision ever in these circumstances. So let me perhaps if we could just work through the three triggering mechanisms, and I can unpack some of the competing criticisms about choices that are made in respect of each of those three mechanisms. Let's start first with state party referral. If in relation to the referrals by the DRC, the Central African Republic, Uganda, Mali, the prosecutor said, no, sorry, can't help, then the criticism was, but that's exactly what the court's been set up to do. How can you not take on these cases? Well, she didn't say that, and her predecessor also didn't say that. Instead, the answer was, yes, okay, let's move to formal criminal investigation. But then the criticisms are, but you're just pandering to state interests. This is a lack of independence by the prosecutor. Here, the prosecutor is just sucking up to the governments that have referred the situations. When Uganda referred the situation in its country, it said to Mrs. Bensouda, the current prosecutor's predecessor, Mr. Moreno Ocampo, that it wanted to refer the Lord's Resistance Army. And Mr. Ocampo said, no, you can't do that. I won't accept a referral that refers only one side of the conflict. If you refer a situation, you refer the situation, and I reserve to myself the discretion, the prerogative to determine whether or not to investigate anybody from any of the parties associated with the conflict. Well, that's good in principle. But in each of the four situations that have been self-referred and have become the subject matter of formal criminal investigations and the issuance of arrest warrants and trials that have been conducted in The Hague, from the DRC, from the Central African Republic, from Uganda and from Mali, there has not yet been a single arrest warrant issued in respect of any senior government representative or senior government military representative from any of those four country situations. Now, of course, I mean, that can be criticised, that reality can be criticised on the basis that that's thoroughly politicisation of the office if you're only going to investigate non-state armed groups or other parties to the conflict, not the governments themselves. But others would say, well, that's a very pragmatic approach because the court is thoroughly dependent on the cooperation of each of those four governments to undertake its criminal investigations and to receive physical custody of the individuals that it issues arrest warrants against. Another explanation, of course, is that the evidence that's emerged from each of those four situations has led to individuals from non-state armed groups as those most responsible for the most serious offences under the Rome Statute. But the criticism tends not to be focused on that option or that possibility, but on pragmatics versus politicisation. So then let's move to the second triggering mechanism, UN Security Council referral. If self-referral by states, self-interested states referring their own situations to the prosecutor is too close and not at arm's length enough, then surely the UN Security Council is more objective about things. Oh, no. If you take on the referrals of the Security Council, then you're only doing the bidding of the 5 permanent members, is the criticism. I should say, these aren't necessarily my own positions. I'm just trying to explain the tensions here. This is a north versus south issue. The UN Security Council will never refer a situation from Guantanamo Bay, from Chechnya, from Tibet, or from Syria, or from Myanmar, or any other situation where one of the 5 permanent members of the Security Council has a vested national interest. So as soon as you say yes to the P5, then you've been sucked in to do their bidding in those conflicts that the P5 decide aren't sufficiently of national interest to them. But the counter-criticism, if the prosecutor was to say no to those referrals, will be that the fact that Rome Statute crimes are going on elsewhere outside of these situations isn't a justification for not taking on Syria and the Darfur situation in Sudan. Sorry, not Syria, Libya, and the Darfur situation in Sudan. Yeah, maybe. But here rises another problem, because there is not a single accused in relation to both Darfur and Libya. The ICC has issued a number of arrest warrants for those allegedly responsible for serious Rome Statute offences. Not a single individual, the subject of an arrest warrant in either situation, is in physical custody in The Hague. And this is because, in my view, the UN Security Council has been unwilling to take substantive action in either situation, to put pressure on the governments themselves, the governments of Sudan and Libya respectively, or to put pressure on international organisations or other governments where individuals are subject of arrest warrants from those two situations visit, including particularly Omar al-Bashir, the incumbent president of Sudan, who travels regularly to other African countries, some of whom are states parties to the Rome Statute. The Security Council has done absolutely nothing to back up its referrals of these two situations. And what does that do for the credibility of the court? So we move to the third triggering mechanism, the prosecutor taking her own initiative, acting proprio motu. Again, the criticism occurs on both sides. On one hand, when she proceeds with those situations, well, the International Criminal Court's not prepared to stand up to the powerful states. It's timid. It's pandering to state interests because it's prepared to refer or to go to the pre-trial chamber for approval in relation to Kenya or Cote d'Ivoire or Georgia. But what about Afghanistan and Palestine? Well, in fact, the prosecutor has made the request of the pre-trial chamber in respect of Afghanistan. And Palestine, in just a few weeks ago, the Palestinian Authority referred the situation in Palestine, and many people are waiting with bated breath to see what the prosecutor will do by way of response. But many people would say to deal with these situations and not others is inconsistent, or even worse perhaps, is a politicisation of the role of the court. Some would say the prosecutor's being too deferential to states, and others would say she isn't being deferential enough. Some would say she's being too reflective of the powerful states and their interests. Others would say she's been too disruptive of the powerful states and their own interests. I think it's really interesting. It is an interesting moment in time for the ICC now, because all of these controversies and tensions that raise questions about decisions that the prosecutor makes are probably going to pale into insignificance compared to the controversies that I see, not in the not too distant future, perhaps the next 5 years or so, as even more powerful for the prosecutor to deal with, and not her alone, the institution of the ICC. The fact is that the first 4 self-referrals by states all involved non-international armed conflicts, and the overwhelming majority of those accused were nationals of those 4 states parties. No issues really about the ICC having jurisdiction because of the consent of the territorial state. There's a lot more agitation around the UN Security Council referrals because of the lack of UN Security Council support, and also around the proprio motu requests from the prosecutor of the pre-trial chamber, because these countries, Kenya, Cote d'Ivoire, Georgia, have all raised challenges to the effectiveness of the court. In the Kenya cases, one of the cases was dismissed and the other withdrawn. The charges were withdrawn by the prosecutor because of allegations that the key accused had bribed witnesses and undermined the prosecution case against them. In the case of the Cote d'Ivoire, while the Ivory Coast was prepared to hand over the former President Laurent Gbagbo, they have refused to hand over his wife, Simone Gbagbo, who is also wanted by the ICC, because they want to try her domestically for charges of embezzlement of public funds and don't want to release her to the ICC. And that's raised some questions about how effective the court really is. But Georgia perhaps takes the tension to a new level, because in the Georgia situation, as I mentioned earlier, the prosecutor is looking not only at the conduct of Georgian government forces, but also at the conduct of Russian government forces on the physical territory of Georgia. And Russia is not a state party to the Rome Statute. And the Russians, perhaps understandably, are not happy about the fact that the court purports to have jurisdiction over the conduct of its own armed forces when it chose not to subject itself to the jurisdiction of the court by not signing up to the Rome Statute. That's, for me, just a foretaste of what is to come. If the pre-trial chamber gives approval to the prosecutor to open a formal criminal investigation in Afghanistan, the prosecutor's already said she will be looking not only at the conduct of the Taliban or the conduct of Afghani armed forces, but also at the conduct of the US and other allied nations who have contributed troops to fight with the Afghani government against the Taliban, including the US. And in relation to the US, she has said in her claim to the pre-trial chamber asking for approval to open a formal criminal investigation that she is concerned not only about allegations of systematic detainee torture and abuse in Bagram Air Base and other places in Afghanistan by US armed forces from 2003 until 2005, when the Obama administration changed its interrogation practices, but also at the conduct of alleged CIA activity that involved the use of black prisons outside of Afghanistan, where individuals were flown from Afghanistan to those prisons and allegedly tortured in them. Palestine, the Palestinian Authority, has referred the situation in Palestine, and Israel is not a state party to the Rome Statute. The allegation by the Palestinian Authority is that the court has jurisdiction over the conduct of Israeli Defence Force personnel in Gaza and over Israel's conduct in its occupation of the West Bank. Very controversial indeed, and in my view, all the controversies that have preceded these situations will pale into insignificance if the court proceeds to exercise its jurisdiction in respect of some or all of them. And this is all without the court even exercising jurisdiction over the crime of aggression, which has recently been added to the statute just last year, and will give to the court jurisdiction over those individuals allegedly responsible for participating in illegal war, in resort to illegal force, in certain limited situations in the future. That will be even more controversial, arguably, than the court exercising jurisdiction over genocide, crimes against humanity and or war crimes. Well, let me try to move to some conclusions, and then if any of you have questions, to take them. What do we make of all of this? How does all of this help? Or doesn't it help? Is it only just revealing problems? I know it's pretty bleak and foreboding. I think there are several things to draw out of this analysis. First of all, I hope that in dealing with these sorts of tensions and controversies, and I should have said earlier that I've been drawing unashamedly from the work of a good friend and colleague in Canada, Darryl Robinson, published a wonderful article which he described as inescapable dyads, articulating and analysing these tensions that he believes are inherent in all the decisions that the prosecutor makes. I think it's a great analysis. As a consequence of Darryl's work and of others like myself picking up on it and commenting on it, I hope that we might deepen the debate around the work and the efficacy of an institution like the ICC. When the court was first set up, the analysis was fairly unsophisticated, quite shallow in my view. People talked about the importance of ending impunity for atrocity, and the skeptics said, well, that's not going to happen. And I think what we have understood from the last 15 years of the ICC's operation is that it's a really challenging environment for the court to operate in. That's not a reason for it not to do its best, of course, but it is the reality that the court faces. So in addition to a hope that we become a little bit more nuanced in our analysis of an institution like the ICC, a question that I ask myself from time to time is Is this all an existential threat to the court? And I guess the best answer I can give is I sincerely hope not. I hope that because of the natural progression of the ICC as the, so far, pinnacle in an evolutionary process of the development of institutions to deal with these egregious violations of international criminal law, I really hope that the Assembly of States Parties, the critical decision-making body about the future of the court, stays committed to this institution and to working with its organs to make it as effective as it possibly can be. But I guess I can't put my hand on my heart and say there's no chance that at some stage in the next period of time, perhaps the next medium to longer term period, over the next 5, 10, 20 years, that the Assembly of States Parties doesn't decide, you know what, this is actually all too hard. And perhaps the court, perhaps we're not really ready for a court like this. That would be a huge shame in my view. And perhaps it could happen that the Assembly of States Parties that determines the budget of the court strangles the institution by squeezing the funding to it. And that could end up having the same effect over a longer period of time to just saying it's all too hard, let's end it right now. Now, that analysis, which is about potential possibilities, is a contested thing to say, and I accept that. There are plenty of people who would argue that the ICC should just stick to what it was set up to do. But there are others who would say the ICC should actually do what it was set up to do. And both of those reveal different perspectives about the court and its effectiveness. In the end, it is for the Assembly of States Parties and the UN Security Council to decide how much support they're actually going to provide to this institution, what the level of resolve will be to assist the court in taking into custody those who are the subjects of arrest warrants and still at large. It will be for the Assembly of States Parties and the Security Council to determine the quality of those who are nominated and elected as judges and prosecutors of the International Criminal Court, and absolutely to allocate the financial resources to allow the court to do its work. So what about those who are involved in the work of the ICC, the personnel that make up the institution? My role is honorary. I'm a bit player on the fringe here. There are many others whose professional career it is to make the ICC work. Their role, in my view, is to continue to do as professional a job as possible, but in the full knowledge that every decision that's made will be criticised and that much of the criticism will be credible and plausible, because there is no perfect decision to be made in such a highly politicised context. And it's also important, I think, for staff of the court to understand that they cannot and do not determine the future of the institution, and that their responsibility is to act professionally, to act responsibly, to do the best that they can on the basis of the evidence that they receive, in the knowledge that the future of the institution is out of their hands, other than that the Assembly of States Parties hopefully will stand with the organs of the court because of the professionalism of the staff involved. Thanks very much for listening. I'm looking forward to seeing if any of you have any questions you'd like to ask.
Thank you very much, Tim. As mentioned at the beginning of this webinar, we have invited live questions to the live stream as it's progressed. We haven't actually received any questions, Tim, which is surprising to me, because that was a great webinar in terms of your expertise and knowledge on the evolution of the ICC and the challenges that it may face in the future. But I do note that we will have the webinar link distributed to our alumni community after this session. It will also be posted on our live stream page and become part of our living library and a living record. So without further ado, I would like to formally thank you, Professor McCormack, for your knowledge, expertise and the time you have shared with us today at this afternoon's webinar, and also for joining our university and bringing your strong sense of humanity too. Thank you to our members of our alumni community who have also watched our webinar series this afternoon, and we look forward to bringing to you more content in the future. Thank you.